Dear students, today we can take up the problem under administrative law, which is to be given normally under KSLU question papers. So here, probably I used to made you clear that with regard to the with regard to the uh, with regard to the what has to be done, how to solve the problems which is to be given under the law exams, how to solve the problems under law exams. There is a specific method is there, that is international method is there, that is issue, rule analysis and conclusion. If students, if you follow this method, you can easily solve any sort of the problems, not giving room for the ambiguity. That means if you do not follow this method, then your answer may end up in some other destination. So that's why the international method, what the law schools which can follow the method in order to solve the law problems is this IRAC method or FARAC method. So this aspect I used to make clear in my all my videos. Here we can go to the problem now. Here, the problem has been given: an Indian citizen with LLB and 20 years of age has to enroll as an advocate. Here, he has to undergo the test that is prescribed with the Bar Council of India. So, here he challenges the test in order to make his enrollment as an advocate. So he has challenged the constitutional validity of the such test, whether it is constitutionally valid or not. Here he has to challenge the constitutionality of that test. Here we have to go to the what we call Advocates Act. Here Advocates Act, which has given the power to the Bar Council of India to prescribe the rules. So that aspect we know. That means this is the very important concept under the administrative law, that the under Advocates Act, the power has been given for the Bar Council of India to make the rules. It may be with regard to the any of the aspect. It may be with regard to the election of the members of the council or administration of the council or seniority in the state roles, or it may be anything. Likewise, there are certain times the what you call the state bar council, which gives the power to the Bar Council of India. So there, what happens? The Bar Council of India often and often make the rules. For example, if the person crosses the age of 45 years, he could not able to what you call he could not able to enroll as an advocate. Likewise, there will be in certain times it has been given in order to get the what you call the enrollment. The person he has to pre-enroll, he has to pre-enroll for the training and the apprenticeship. Likewise, certain times the Bar Council of India, which has been the powers which has been given, the powers which has been delegated under the Advocates Act, it used to make the rules. So here the person is challenging such rules with regard to the making the test as a mandatory to for the purpose of enrollment. Here what we have to do, here we have to write the issue after the problem has already been given under question papers. We have to highlight the issue. Is the Bar Council of India's test to claim the right to practice law constitutionally valid? Likewise, we have to frame the issue. Then our answer will go in such a way that we can what we can do, we can solve the problem in the effective way. Here in the problem also they have asked the same thing: constitutional validity of the test. That means constitutional validity of the rules made by the Bar Council of India. So here how far it is constitutionally valid, that means this aspect we have to discuss. So when we speak with regard to the constitutionality, then we have to go with regard to the which is the article is in connection with the such aspect. Here, probably you know, under Article 19(1)(g), it grants the what you call fundamental rights to citizen to practice any avocation, occupation, or profession. So this aspect has been given under Article 19(1)(g), but it's not absolute right. That you know there are certain there are certain limitations has been given under Article 19 class 6 with regard to this article. Here we have to discuss. That means, so when this Article 19(1)(g), a person has got the right to practice any profession, occupation, or avocation. At the same time, there will be some limitations will be there. That means that limitations, that reasonable restrictions, which will be in order to maintain the professional standards. So, likewise here also, under the Advocates Act, what has been done in order to maintain the unity and dignity of the profession, the Bar Council of India, which can prescribe the rules, the power has been guaranteed and the power has been delegated to Bar Council of India under the Advocates Act. So, this aspect we have to discuss here with regard to this problem. So, likewise here under certain case laws, it has been proved that the Bar Council of India has got the power to frame the rules with regard to such aspect. Here in Bar Council of India versus Boni, Foy, Law College and others, it has been upheld by the Supreme Court that the Bar Council has got the power to make the rules for the entry of the advocates, to enroll for the advocates, to pass the exams conducted by the All India Bar Examination, that is AIBE. This aspect it has been clarified, and you have to write this aspect, and you have to discuss with regard to the certain sections concerning with regard to the Advocates Act, that is section 71 subclass 1 subclass H and section 49 subclass 1 subclass AH. Likewise here we have to discuss certain aspects. That means what has to we have to establish. Here there are certain legal principles will be established by the outcome of this article discussion. Here first one is Article 19(1) class G can be regulated in the interest of the public through reasonable restriction. This aspect I have told you. And next one is BCI, that is Bar Council of India, being the apex body for legal education profession, has powers to maintain the standards of the legal education. That means it can make the rules for the to uphold the standard and dignity of the advocate profession. From time to time, it can make the rules. That power has been given under the Advocates Act. And AB is a reasonable post-enrollment qualification and does not infringe the constitutional rights. This is the outcome of this aspect. Here, what is the conclusion is that the challenge to the constitutional validity of the AB is not sustainable. This aspect you have to write in your answer. That means when you follow these steps with regard to the what is issue, what is provision of law, what is the analysis, and ultimately what should be the conclusion. So you have to write this is the what you call the rules of the BCA, that prescribing the some what you call test or examination will be constitutionally valid. That means the Supreme Court has upheld this aspect in the above case, that it is constitutionally valid. Such a test is constitutionally valid. Further, the court has stated that right to practice not an absolute right. That aspect we have discussed, and is subject to reasonable restrictions in the interest of maintaining professional standards. This aspect you have to keep in your mind. And the examination was deemed to be regulatory mechanism and is not the violation of the fundamental rights. That means it is the common thing. Even though the student might have written the exams, that is, he has written the LLB exams, he has cleared the LLB, but for the purpose of what we call the suitability for the upholding the professional standards, it is the Bar Council, it can conduct the separate examination. So this examination was deemed to be a regulatory mechanism and not the violation of the fundamental rights. So ultimately we can say that conclusion is the rule prescribing the test is constitutionally valid. let us discuss certain more problems. That means, as far as possible, I wanted to cover all the previous problems under the administrative law, and uh, I have discussed the majority of the problems of the torts, and I have covered the contract one, contract two, and certain videos with regard to the problems of BNS, and I have done certain videos with regard to the constitution also I have done, and in future I will cover the all the problems of the law. So please follow this method to score the good marks.